Imagine a single voice holding the ultimate power to define justice, to interpret the very bedrock of a nation's laws. One person with the final say on everything from your freedoms to the structure of your government? Sounds powerful, doesn't it? Perhaps even a little dangerous? This isn't a hypothetical. This is the U.S. Supreme Court, the highest court in the land. But here's the twist. It's not one voice, it's 9. 9 individuals, cloaked in black robes, who collectively wield this immense power. But why 9? Why not just one all-knowing legal guru? And if they're all looking at the same constitution, the same laws, why do they so often come to wildly different conclusions? And why don't they just ask Congress, the people who write the laws, to clear things up? These aren't just academic questions. They cut to the very core of how America works, how our rights are protected, and how justice is served. So, let's pull back the curtain on the enigmatic world of the Supreme Court. When the United States was born, its founders were wary of concentrated power. They'd just fought a revolution against a king, remember? So, when they drafted the Constitution, they left a crucial detail blank: how many justices it should have. It was Congress, not the Constitution, that first set the number. In 1789, they decided on 6 justices. Why 6? Well, back then, Supreme Court justices also had to ride circuit, traveling across the country to hear cases in lower federal courts. 6 justices could conveniently cover the 3 judicial circuits that existed at the time. But America grew. New states joined, new circuits were created, and the number of justices fluctuated. It went up to 7, then 9, even briefly to 10 during the Civil War era, as President Lincoln sought to ensure an anti-slavery majority. Congress even tried to shrink the court to 7 to limit President Andrew Johnson's power to appoint justices. Finally, in 1869, Congress settled on the number 9, and it's stayed that way ever since. So the magic number isn't some ancient decree, it's a historical accident, solidified by over a century and a half of tradition.
The evolution of the number of justices reflects the nation's adaptation, not a divine formula. It's a testament to the system's flexibility, allowing it to grow and change with the country itself.
But beyond history, there are powerful practical reasons why a single justice would be a disaster. One person, no matter how brilliant, is susceptible to personal bias, error, or even corruption. 9 voices ensure a check on individual power. Imagine a complex puzzle like a nationwide healthcare system or a new technology's impact on free speech. One mind might see only one solution. 9 minds from different backgrounds, legal schools of thought, and life experiences will approach it from various angles, leading to more robust debate and, hopefully, better, more nuanced decisions. The Supreme Court receives thousands of requests to hear cases every year. Even with 9 justices and their teams of clerks, they only hear about 60 to 70 cases annually. One justice simply couldn't handle the immense volume of legal work. An odd number of justices, like 9, helps prevent tie votes. While ties can still occur if a justice recuses themselves or a seat is vacant, an odd number generally ensures a majority decision. A tie means the lower court's ruling stands, which can lead to inconsistent law across the country. So the 9 robes aren't just a tradition, they're a safeguard, a mechanism for collective wisdom, and a practical necessity for the functioning of American justice. This is where it gets really interesting. If the law and the Constitution are already written, why do these 9 brilliant legal minds interpret them so differently? It's because the law isn't a recipe. It's more like a complex work of art, or a foundational blueprint with intentionally broad strokes. The words are there, yes, but their application to new, unforeseen situations requires interpretation. And that's where judicial philosophies come in. Think of them as different schools of architecture for interpreting the constitutional blueprint. These justices believe the Constitution should be interpreted based on its original meaning when it was written or ratified. They act like diligent historians, poring over the text itself, looking at dictionaries from the 1700s, and studying the writings and debates of the Founding Fathers to understand their original intent, or the original public meaning of the words. To prevent judges from injecting their own personal views or modern values into the law, for them, the law is fixed, and if society wants to change it, they should go through the democratic process of amending the Constitution, not rely on judges. When considering a case about digital privacy, an originalist might struggle to find a direct constitutional protection, as the framers couldn't conceive of the internet. They'd look for broader principles that might apply, but would be hesitant to create a new right not explicitly rooted in the original text. These justices see the Constitution as a living document, one that must evolve and adapt to the changing needs and values of society. They believe the framers intentionally used broad language to allow future generations to apply its principles to new circumstances. To ensure the Constitution remains relevant and effective in addressing contemporary challenges, protecting rights in ways the framers might not have specifically envisioned, but that align with the document's overarching goals. In the same digital privacy case, an urban planner might argue that the spirit of the Fourth Amendment, protecting against unreasonable searches, extends to digital data, even if the technology didn't exist in the 18th century. They consider how modern society understands privacy.
The tension between these philosophies is inherent to our Constitution. It's not a bug, it's the engine that drives legal debate and allows the document to remain relevant across centuries.
It's crucial to understand that both architects and urban planners genuinely believe they are upholding the Constitution. They simply have different methods for doing so. Beyond these philosophies, other factors contribute to differing opinions. Justices are not robots. They bring their own life experiences, educational backgrounds, and even subtle biases to the bench. While they strive for impartiality, their worldview can influence how they weigh arguments or the implications of a legal argument. Justices generally respect stare decisis, the principle of standing by things decided, meaning they usually follow past Supreme Court rulings. This provides stability. However, even precedents can be interpreted differently, or in rare and momentous cases, a majority of the court might decide that a previous ruling was fundamentally wrong and needs to be overturned. Example: Brown versus Board of Education, overturning Plessy versus Ferguson. When the court interprets a law passed by Congress as statute, they also employ different methods. Some focus strictly on the words of the law, textualism, while others try to discern Congress's broader purpose or intent when passing the law, purposivism. So, when you see a 5-4 decision, it's often not about personal animosity, but a deeply held philosophical disagreement about the very nature of law and how it should be applied to the complex realities of modern life. This brings us to the third big question. If the Supreme Court is so divided on an interpretation, why don't they just pick up the phone and ask Congress, "Hey, what did you really mean by that law?" Or even, "Can you clarify this part of the Constitution?" The answer resides in the ingenious yet sometimes frustrating system of separation of powers and checks and balances on which the U.S. government is built. Each branch has its own distinct role, and it's essential that they remain independent of each other to prevent the concentration of power. In the landmark 1803 case of Marbury versus Madison, Chief Justice John Marshall famously declared, "It is emphatically the province and duty of the judicial department to say what the law is." This established the power of judicial review, the court's authority to interpret the Constitution and laws, and to strike down any law or government action that it deems unconstitutional. This is their job. If they ask Congress for clarification on constitutional matters, it would undermine their independence and their role as the ultimate interpreter of the nation's supreme law. It would be like asking the referee of a game to consult with one of the teams on how to interpret the rules. The Supreme Court only hears cases and controversies. This means they only interpret laws when there's an actual legal dispute brought before them. They don't issue advisory opinions, hypothetical interpretations, or clarifications outside of a specific case. This further limits their ability to just ask Congress for a general clarification. The system is designed for a dialogue of actions, not direct consultation on interpretation. If the court interprets a statute, a law passed by Congress, in a way Congress didn't intend, Congress can pass a new law or amend the existing one to clarify its original intent. This is a common legislative response to judicial decisions. The court's ruling stands for the case it decided, but Congress can change the law for future cases. If the court interprets the Constitution in a way Congress and the states strongly disagree with, the only way to directly overturn a Supreme Court constitutional ruling is through a constitutional amendment. This is an incredibly difficult process, requiring a 2/3 vote in both the House and Senate, and then ratification by 3/4 of the states. It's a high bar, designed to ensure that the Constitution's fundamental principles are not easily modified by fleeting political majorities. Imagine the chaos if the court constantly had to wait for Congress to clarify every ambiguous phrase. Congress is often gridlocked, and reaching consensus on complex legal interpretations would be nearly impossible. This would paralyze the judicial system.
The separation of powers is not a barrier, it's a mechanism of balance. It ensures each branch fulfills its function without encroaching on the others, preserving the integrity of our governmental structure.
So, while it might seem inefficient at times, the system is designed to maintain the independence of each branch. The Supreme Court's role is to interpret, and Congress's role is to legislate. They act as checks on each other, ensuring that no single branch holds all the power to define the law of the land. The U.S. Supreme Court, with its 9 justices, its differing philosophies, and its unique relationship with the other branches, is a testament to the complexities and resilience of American democracy. It's not a perfect system, and its decisions are often met with fervent debate and strong emotions. But it is a system designed for deliberation, for checks and balances, and for the ongoing interpretation of a foundational document intended to endure for ages to come. The differing interpretations aren't a flaw, they are in many ways a feature, a reflection of a vibrant democracy grappling with profound questions about justice, liberty, and the meaning of its own governing principles. The 9 robes may interpret the same words differently, but in doing so, they collectively shape the living, breathing law that governs the lives of millions, ensuring that the grand experiment of American self-governance continues to evolve. What do you think? If you enjoyed this video, please like and subscribe for more insights into how our world works.